on the reputation of Parliament as an institution that makes laws prospectively and with advance notice to the public before implementation. So to this end, I believe the recent episode of the Urgent Insurance Amendment Bill targeting the Alliance Income deal may have dented Parliament's reputation. The Workers' Party expressed serious misgivings about the proposed acquisition of income insurance by Alliance, but we did not support the bill. As my party colleague Ms. He Ting-Ru had argued then, the legislation affected a live transaction and would undermine legal and business certainty that was critical to a business hub such as Singapore. In that debate, Deputy Speaker Christopher D'Souza opined that the bill was a hybrid bill. He explained that although the provisions of the bill were drafted in general terms, it was clear that the bill was, in substance, aimed at the proposed acquisition of income by Alliance. Ordinarily, the standing orders would require that such a bill be referred to a select committee for close scrutiny, since it affected prejudicially the rights of particular parties. But because a certificate of urgency was obtained, the select committee procedure was done away with. This deprived Parliament of the opportunity to hear from the affected parties themselves before passing the bill. So while the circumstances may have required it, such certificates of urgency should be deployed as a last resort. For example, the urgent bill could have been avoided had the lacuna in MCCY's regulatory ambit been identified in 2022 when income's corporatization exercise was approved. So this episode is a salient reminder of what is at stake: our reputation as a legislative body that respects the fundamental rights of the rule of law in the discharge of our responsibilities.
On reputation of Parliament, let me just say at the outset that actually just bringing a bill quickly on the certificate of urgency is not the most important consideration when it comes to reputation of Parliament. For the reputation of Parliament, what is most important is that MPs conduct themselves with the highest standards of conduct, with integrity, do not mislead people outside as to what happened in Parliament, and also speak the truth to Parliament and its committees. Now, let me deal with the specific instance that Ms. Lim raised. Just find that. So the issue that Ms. Lim raised was bills which are presented on an urgent basis. Now, our system ensures that members do have sufficient time to review the bills and to debate them robustly in this House. Bills are introduced at prior sittings, and as a general rule, there must be 10 clear days between the first and the second readings of a bill. Hence, MPs generally have about a month to go through each bill, which forms the basis of the minister's second reading speech. However, there may be situations where it's necessary for a bill to be brought for second reading at short notice. Hence, our system also allows for a bill to be presented under a certificate of urgency on the rare occasions when there is a need to do so. On the bills that were presented under certificates of urgency during this term of government, there was the COVID-19 Temporary Measures Bill and the 3 amendment bills thereafter, as well as the other COVID-related bills. Then we had the one that Ms. Lim talked about, which was the Insurance Amendment Bill in October 2024. The purpose of the bill was to allow the minister in charge of MAS to impose conditions on an approval of an application to obtain effective control or become a substantial shareholder of a licensed insurer where a co-op is concerned. This was necessary because the proposed deal by Alliance was under active consideration by NTUC Income shareholders at the time. A long duration between the first reading and the second reading of the bill, and thus a delay in the amended law taking effect, would have given rise to even more uncertainty in the market and for the parties concerned. And Minister Edwin Tong had explained this context in his ministerial statement when the bill was introduced. So we will always respect and uphold due process in this House to ensure fairness and maintain trust in our institutions. But from time to time, there may be exceptional circumstances, such as in the case of the Alliance Bill, that call for us to be an agile legislature so that we can best serve Singaporeans. Measures such as certificates of urgency have been and will continue to be used sparingly and only when necessary.
Topic I raised on legislative process, actually I think Leader kind of missed the main issue, which was that, as pointed out by the Deputy Speaker at that sitting, the Insurance Amendment Bill was a hybrid bill that directly affected particular parties. And under the standing orders, it is supposed to be the norm that if there are such bills, then a select committee has to be formed so that Parliament can hear directly from the affected parties on how the proposed bill would affect them. And in this situation, we're talking about a really important social issue, and the MPs were deprived of that opportunity to hear from the parties because the certificate of urgency was issued, and therefore the bills were just passed without the select committee procedure being activated. So I think to that extent, Parliament has been prejudiced.
Then the second point on the legislative process and the Insurance Amendment Bill, I do take Ms. Lim's point that in the normal case, it would go to a select committee, but the standing orders also do provide that in an urgent case, then it need not go to a select committee. In other words, when the standing orders were designed, it was thought about, and you do realize, you do anticipate that there may be situations that are urgent, because when you go to a select committee, it takes time. And in this particular instance, given that there was concerns with the market, as I've explained, there was urgency to do it. And that is why a certificate of urgency was brought. So in other words, it is not that every day we have urgent certificates. In this particular instance, there was a need to do it quickly. And that was already explained by Minister Edwin, so it's unnecessary for me to go into that detail.
Regarding the urgency of the Insurance Amendment Bill, I just, of course, to note that the deal has been aborted. So I do not know whether the parties felt that they were inadequately listened to. So I do not know the answer to that. But sir, in any event, there are clearly many interesting issues that we can talk about about Parliament and its functioning. And I would hope that there's common cause that all of us want Parliament to be effective. And with that, sir, I beg leave to withdraw my amendment.
With respect to the last question, when she raised the issue about the bill being aborted and what is the response. Now, this is a classic example of a question that should not be directed to me. That should go to Minister Edwin Tong. So if the member has any clarifications on that, that's something to be directed to Minister Edwin Tong.